Good afternoon. This is Brian Nagatani with the law firm of Hickson Nagatani LLP. I want to welcome you to today's webinar, Changes California Employers Need to Make by January 1st, 2023. We have over 1,800 registrations for today, so thank you very much for your interest in this webinar. For those who are not familiar with our firm, Hickson Nagatani is a boutique employment law firm based in San Jose, California. We provide proactive advice to employers on legal compliance, including with regard to all the topics we'll discuss today. We also defend employers in employment law litigation. My co-presenters today are my partners, Ray Hickson and Mary Wang. Ever since 2009, we've been partners here at Hickson Nagatani. Before turning to today's topics, I want to cover a few logistical matters. First of all, as far as audio, we find that dialing in by telephone typically provides for the best quality. For those of you who were registered by a little after 11 a.m. today, you should have received a blast with our materials. If you did not receive that blast, we will be resending them again after the webinar. And finally, with respect to Q&A, you'll see in your GoToWebinar dialog box, there's a section for questions where you can type in your questions. At the end of each of our sections, we'll pause briefly to take a couple of questions, but then we'll also try to type in answers to some questions as the session progresses and at the end of the session as well. We'll try to reach as many questions as we possibly can. Now I'll give you a quick overview of the topics we'll cover today. I'll begin by covering updates to the California Families every employer in California, and the changes will dictate necessary changes to leave of absence policies in your employee handbooks. I'll talk about some of these changes that are necessary. I'll then discuss a new law that may necessitate changes to your handbook's substance abuse policy based on cannabis use. And finally, I'll discuss wage and hour updates, including a couple of cases that impact timekeeping practices for non-exempt employees. Ray will then discuss California's new pay transparency law, Senate Bill 1162. This significant law will impact how employers must manage job postings as well as pay scales. And at this point, I'm receiving calls from clients about this almost daily, so this has definitely become one of the hottest topics in California employment law. Ray will then discuss new state employment laws outside of California and how to address these in your handbooks. And he'll discuss how to manage electronic workplace postings for remote workers. Finally, he'll discuss an update regarding the ability to have mandatory arbitration agreements in California. Then Mary will discuss our ever-evolving changes to COVID-19 employment-related laws, including California's recent extension and amendment to the supplemental sick leave requirement and duties of an employer when it's notified of a potential exposure to COVID-19. And she'll also discuss a new law regarding California's workers' rights in emergencies. We have a lot to cover, as you can tell, so let's dive right in. Back on January 1st, 2021, the California Family Rights Act was significantly expanded to include any employer with 5 or more employees, down from the prior threshold of 50 employees. So this means that virtually every employer in California will now be impacted by the new changes to the CFRA that go into effect on January 1st, 2023. And these occurred through Assembly Bill 1041. So what the changes do is that they expand CFRA leave for a serious health condition to care for a, quote, designated person. The CFRA amendments define a designated person as any individual related by blood or whose association with the employee is the equivalent of a family relationship. So it's a pretty broad definition as to those people whom an employee can take leave to care for. And a designated person may be identified by the employee at the time the employee requests leave, so there's no advanced designation requirement aside from the standard 30-day notice required where the leave is foreseeable. An employer can limit an employee to one designated person per 12-month period for family care and medical leave. So you at least have some restriction there, some control over who an employee can take leave to care for. And additionally, as with leave for caring for other family members, an employer can also request certification, medical certification, supporting the need for the leave to care for a designated person. Assembly Bill 1041 also expands the definition of who employees can take sick leave for by adding in a designated person in the definition of the family member here as well. And this definition is even broader than the definition that's written into the CFRA for family and medical leave. So it expands the definition, and it states that a designated person is defined as a person identified by the employee at the time the employee requests paid sick days. No other limitations. It doesn't have to be a blood relative, and it doesn't have to be the equivalent of a family relationship. It can essentially be anyone. But again, employers here have the power to limit an employee to one designated person per 12-month period for use of their paid sick days. Now, with respect to this designated person definition under the sick leave law amendments, the concept of a designated person may already have been familiar to you because that concept exists in many local sick leave ordinances. But there are some important distinctions between what AB 1041 does and the local sick leave ordinances. Those being, in particular, San Francisco, Berkeley, Oakland, and Emeryville's sick leave laws. So under these four sick leave laws, the use of a designated person is only permitted if the employee has no spouse or registered domestic partner. There's no limitation under California's new amendments. So can you have two designated people? Because the new California law is silent on this issue, we believe a safe approach would be to allow this designation under the local sick leave laws, as well as designation under California's sick leave law. So for now, without any further guidance, the safe approach is to allow two designated people. Now, under local laws, another distinction is that the employee can make their designation no later than the date on which the employee has worked 30 hours after sick leave begins to accrue. And the employee has 10 work days to make the designation, except in Emeryville, they have 14 calendar days. So again, that's the distinction with the local sick leave laws. And again, with the local sick leave laws thereafter, an employee can only identify a designated person annually within a 10 workday window or 14 calendar days in Emeryville. Whereas under state law, the employee can make their designation at the time they request sick days. Now, other sick leave laws around the country also have different variations, which should be captured by handbook appendices. And this is something that Ray will discuss in detail a little bit more when he's also discussing local employment laws. Now, Assembly Bill 1949 is another addition to the California Family Rights Act, and this bill creates a protected entitlement to bereavement leave. Previously, bereavement leave was something that would have been governed by your company's employee handbooks, but Assembly Bill 1949 now creates a statutory entitlement to bereavement leave. But the entitlement under, even though this is an addition to the California Family Rights Act, the entitlement under Assembly Bill 1941 provides leave in addition to the leave that employees are already entitled to under CFRA. So what does Assembly Bill 1949 say? AB 1949 provides for 5 days of bereavement leave upon the death of a family member, and the eligibility under this law is that you have to have been employed for at least 30 days prior to the commencement of the leave. But importantly, there's no hours worked restriction. So whereas typical employee handbooks right now provide bereavement leave for, we'll say, full-time employees and part-time employees working over a certain hours threshold, oftentimes 30 hours. Under this new law, temporary, part-time, and staffing agency employees all would also be entitled to bereavement leave. Under the law, 5 days does not have to be consecutive. Again, that's distinguished from standard handbook policies, which currently require the bereavement leave to be consecutive. And under the law, the leave has to be completed within 3 months of the date of the death of the family member. The leave can be unpaid unless you have an existing policy, as many do, that provides for pay, although the employee can use vacation, personal leave, sick leave, or compensatory time off. But the compensatory time off cannot be something that you're providing in lieu of overtime. Of course, that's a whole separate wage and hour seminar. Now, like I mentioned, most handbooks already provide paid leave to benefits eligible employees. So one way to handle this new law, where a much broader scope of employees are receiving bereavement leave, is to keep doing it this way, where certain employees, full-time, part-time employees over a certain threshold, receive paid bereavement leave, and then to create a separate unpaid bereavement leave policy for temporary, part-time employees working below a certain threshold and staffing agency employees. So that's one way to get around this, where the law is not saying that everyone needs to receive paid bereavement leave, but all employees who have been employed for at least 30 days prior to the commencement of the leave do need to receive a form of bereavement leave. And then the law also provides that the employer can request documentation of the death of the family member. So our recommendations coming out of this are to update your policies to comply with these changes to the law. To clients using our current employee handbook template, if you want to send in the handbook for updating, we're prepared now to make these updates. Our updated handbook, or the edits that we've determined need to be made, are set. So you can go ahead and send your handbooks into us for review. It's also important to note that bereavement leave is now a protected form of leave. And it's also important to educate managers regarding changes to the law. For instance, you don't want a manager giving an employee negative feedback in their performance review because of protected bereavement leave that they recently took. Assembly Bill 2188 addresses cannabis use, and it makes it unlawful to discriminate based on an employee's use of cannabis off the job and away from the workplace, or based on a drug screen that finds non-psychoactive cannabis metabolites, i.e. what remains after THC is metabolized and stored in the body. This is something that remains in the body for a while, so drug screens could pick up on this for weeks after someone has used cannabis. And so this new law is designed to address this storage of non-psychoactive cannabis metabolites in the body and ensure that they don't trigger a drug screen that allows an employer to take negative action against the employee or the applicant. Now, employers are still entitled to conduct pre-employment drug screens that don't screen for non-psychoactive cannabis metabolites. And then this law also does not apply to building and construction trades, or for positions that require a federal background investigation or security clearance, and it doesn't preempt other state or federal laws that require testing for controlled substances. So another potential edit to the handbook coming out of this, our recommendation would be to clarify in your handbook substance abuse policies that the testing won't screen for non-psychoactive cannabis metabolites, essentially confirming your compliance with AB 2188. Unless such testing is required, as I noted previously. All right, now shifting gears to wage and hour and minimum pay requirements. As a reminder, effective January 1st, 2023, California's non-exempt minimum wage goes up to $15.50 an hour. Note here, there's no longer two minimum wages that are dependent on an employer's size. Now, as of January 1st, 2023, all employers have the same minimum wage in California. This also means that as of January 1, the minimum exempt salary will go up for white-collar professionals to $64,480 per year. That's 2 times minimum wage. And for computer software professionals, we've provided the attachment from the Department of Industrial Relations that outlines the new minimum exempt salary for computer software professionals as $112,065.20 per year. Computer software professionals are the one exemption where they can also be paid hourly, but that hourly amount has also risen as of January 1 to $53.80 per year. There are a number of local minimum wage ordinances throughout California. So if you have employees in various locations that are governed by these, you'll also want to check increases in these city and county minimum wage rates. But keep in mind that these ordinances don't affect exempt salaries. It's only the California minimum wage that affects exempt salaries. Of course, that said, in California's urban and suburban areas, if employees are receiving $64,480 per year or somewhere very near that threshold, the odds are that they're more likely than not performing non-exempt duties. So if you do have someone classified as exempt that's really near this salary threshold, you'll want to closely examine them to make sure they are in fact performing exempt duties. Okay, sticking with wage and hour updates here, let me talk briefly about time rounding. Rounding time is a method that employers sometimes use just to get rounder numbers of hours worked. So for instance, employers can round to the nearest 15-minute increment. If they did that, they'd round up to a start time of 8:15 if an employee began at 8:08, but then they'd round down to a start time of 8 o'clock if an employee began at 8:07. The idea being that eventually everything balances out. But does it really balance out? So Camp versus Home Depot was a case addressing time rounding issues where Home Depot rounded to the nearest quarter hour, and they said their practice is neutral because, like I just mentioned, sometimes time gets rounded up and sometimes it goes down depending on the punch time. So there were a couple of plaintiffs here. One plaintiff, Coria, was actually paid for all of his time worked. It did in fact even out. But another plaintiff, Camp, had a total net loss of 470 minutes due to rounding. And the court allowed Camp to proceed to trial. The court basically said a few extra minutes of work each day can add up. And in fact, they added up to quite a bit here for Camp. So he was allowed to proceed to trial. The court didn't rule specifically one way or another whether time rounding was permissible, but in allowing him to proceed to trial, where he's going to claim that he didn't receive pay correctly based on this analysis, it looks like he has a decent chance of prevailing. So essentially, the court is allowing him to prevail for his case on time rounding. So our recommendation here is, due to advances in technology, where the exact amount of work now can be tracked by almost every employer, almost everything is computerized now, companies that currently round work time should re-examine this practice. It's more of a time rounding is more of a remnant from times when people used punch cards or, in fact, they recorded their time by hand, but now we're really recording, or most companies are able to record to the second. So with that, courts are going to expect more accurate pay of employees. And as one reminder, time rounding had already been ruled improper in the meal period context because this could deprive employees of their statutorily entitled 30-minute meal period where the time was being rounded. So keep that in mind now. Time rounding, more of a remnant of the past, or we're at least heading in that direction. You definitely want to speak with counsel if that's something that you still do. And then finally, related to that, computer login time, another hours worked type of case. So in this case, Connex wasn't paying its employees for time spent booting up or logging into their computer and shutting down or logging out. And the court said that this work was in fact integral and indispensable to a call center employee's principal duties, and it was therefore compensable. That was the federal Fair Labor Standards Act standard. But related to that our recommendation from this is essentially it's important to remember that you need to examine employee time to ensure they are being paid for all hours worked. California would define hours worked as the time during which an employee is subject to the control of an employer and include all the time the employee has suffered or permitted to work. So an employee would really be subject to the control of the employer if they have to sit at their computer, which they need for work, and sit there while it boots up. So it would likely be, or it's almost certain that a court would find in a similar manner, a California state court would find in a similar manner to what the federal Ninth Circuit found in this case. So with that, let me stop and ask Mary if there is a question or two.
Sure. We had several questions just asking for clarification regarding the California bereavement leave law, whether the 5 days of bereavement leave that must be provided has to be paid or unpaid. And in particular, many employers said that they currently provide 3 days of paid leave. Could they simply just add 2 days of unpaid bereavement leave to that policy?
Yes. So under Assembly Bill 1949, that new law providing for bereavement leave, the law only requires that the leave be unpaid, although an employee is entitled to substitute their vacation or sick leave or PTO for the leave. Now, if an employer already provides paid leave, you would of course continue to comply with your policy. And if you only want to provide 3 days of paid leave, then the remaining 2 days, in order to reach the 5 days required by the law, that can be unpaid, where the employee can substitute vacation, personal leave, sick leave for the time off. Alternatively, you can of course bump the amount of time that you provide under your policy to 5 days. And then as another reminder, you can have a second policy for, let's say, temporary employees, staffing agency employees, part-time employees working less than your hours threshold to qualify for benefits, where their leave is entirely unpaid. Okay, so with that, let me go ahead and turn this over to Ray.
Okay, thanks, Brian. Let me just get my screen going here. One moment. There we go. Let me know if that's not showing, but I think I've got it. So let's talk about pay transparency laws. And it's a big trend sweeping the country to pass these new laws. California has been a leading state in terms of passing new laws to try to promote pay equity, including, you'll remember in 2018, a new law took effect that made it against the law to ask for prior salary history of applicants, and made it against the law to try to justify pay disparities based upon prior salary history. And why is that? Because, well, if female employees, if there's already a wage gap, you know, where female employees are making 83 cents on the dollar to men, and we keep basing current pay on prior salary, obviously that's going to perpetuate the disparity. So California, you know, once again here, starting with a new law in January 1 of 2023, is raising the bar and you know, passing some more innovative new laws. So let's start off with this: that employers with 15 or more employees must include in any job posting as of January 1 the pay scale for the position. And the pay scale is basically referring to a minimum and maximum wage range that the employer reasonably expects to pay. And this requirement, by the way, it applies to direct postings by the employer and also postings by any third party. All right. Employers must also provide the pay scale for a position to any applicant upon request. Now, that has been the law for a couple of years now, but it was tweaked this year to say that that's regardless of whether the applicant has completed an initial interview. Before, you could say they needed to wait until after the initial interview, not anymore. Another new aspect of this law that's taking effect January 1 is that now employers will have to provide employees with a pay scale upon request, so not just applicants. So what is a pay scale? Again, it means the salary or hourly wage range that the employer reasonably expects to pay for the position. We have given you, maybe I'll just switch my screen quickly to one of our handouts, which is a sample pay scale. So this is based upon California law. You'll see that, as we do in pretty much all of our forms, we like to give our clients some guidance and margin comments. So this is noting that this is set up to comply with the California law, but as we will discuss, there's a lot of different variations of these requirements in other states and even cities that you're going to need to comply with as well for any location where you have employees. So get back into the slides. See, one moment here. There we go. And the California law also says that employers must maintain records of job title, wage rate, history for each employee for the duration of employment plus 3 years after the end of employment. I also want to mention that many of these other state and city laws also have record-keeping requirements that, differ in various ways, and so you're going to need to make sure you, get your arms around those to comply with those as well for any place where you have employees, including remote employees. Okay. More on California Senate Bill 1162, that's on or before the second Wednesday of May 2023 and annually thereafter, employers with 100 or more employees must submit pay data reports to the California Civil Rights Department, which used to be called the Department of Fair Employment and Housing. So the name of that department has changed. These reports are for the prior calendar year. Now, the content of these reports, you've been required to submit these reports already if you have 100 or more employees, but I've italicized what's new for 2023. So one thing that's new and a very big deal is that within each job category and for each combination of race, ethnicity, and sex, you now have to calculate and disclose the median and mean hourly rates. So basically, if you've got pay disparities in your company, you are now going to basically have to calculate those and, serve them up to the Civil Rights Department on a silver platter, which of course you should expect that if you've got some bad looking numbers that they will want to audit you for that. In addition, employers with 100 or more employees hired through labor contractors, i.e. a staffing agency, you have to submit a separate report for those. And also, if you have multiple establishments, you have to submit a report for every establishment. Establishment is a very complicated definition, but in essence, it means physical location. That's roughly the definition, although definitely seek some legal advice to get a more precise understanding of that. And I've put a link here on the screen to the California State website where you can get all the detailed information on how to do these reports when the time comes. Now, I do want to run a quick poll here on this topic and see what you all report to us here. So let me just launch this poll. So this should be showing now, and you can vote for as many of these as are true. My company has established minimum, maximum wage ranges for all positions. Have you already done that for all positions? Have you recently conducted internal pay equity analysis? So this is where you're doing statistical analysis inside your company to identify, do we have disparities across gender, race, ethnicity? Have you recently conducted external pay equity analysis where you're comparing what you're paying inside your company to the external market? And last, have you already begun including pay scales in your job postings? Because we do have a state that has required that before California, which is Colorado. And many companies may already be doing that because you have a Colorado employee and you've realized you realized a couple of years ago you had to start doing this. So let's see. In the interest of time, I'll go ahead and close out this poll and share the results. Okay, so let's run through this. So 61% of you have already established minimum and maximum wage ranges. So at least you've got that done, and you have a good start here to get ready for these disclosures. But then we've got 39% that have not done that. So this is kind of a wake-up call to you if you're in that 39% that you need to get ready for, obviously, January 1. Only 44% have done an internal pay equity analysis. So that is something that we have recommended for years, actually, for even decades, you could say. But now that we are going to have to serve up to the Civil Rights Department on a silver platter these kinds of statistics, and now that we're having to be, so much more transparent, with including pay scales and job postings and things like that, well, that's just another huge motivation really for all employers to go ahead and do some, internal pay equity analysis. 39% have done external analysis. So, it's not necessarily against the law to not be competitive in the marketplace, but, for business reasons, it's a good idea to do external analysis as well. And then 33% have already begun to include pay scales and job postings. So, basically we're going to have to get that up to 100% by January 1. So thanks for participating in that. And it's good for everybody, I think, to see, just that we're all in the same boat here. We've got work to do to get ready for January 1. Okay, go back into my slides. One moment. Takes me a minute to get switched around here. All right, we'll go to the next slide. Well, let's highlight some other states' pay transparency requirements, because as we see here with Colorado, if you just have one employee in Colorado, and then you're posting a position that potentially could be performed in Colorado, even a remote position. So you're posting a job where you're flexible about where it could be performed, and you're flexible about it being possibly a remote job. You've got to comply with Colorado law. And Colorado law already has for a couple of years required that you put in your job postings information not only about pay range, but also a general description of other compensation like commissions and bonuses. Also to describe benefits, you've got to put information there about benefits. So, this is obviously requiring more than California. Connecticut has its own disclosure law as well that has a variety of different triggers to it for when you have to disclose the wage range. And, it's got a lot of detail in there. And if you've got a Connecticut employee, you're just going to have to make sure that you drill down on these requirements with your counsel. Maryland has also a version of this with you have to provide a wage range to an applicant upon request. New York City, just the beginning of this month, had a new requirement kick in that you've got to include salary range in an advertisement for a job or for a promotion or a transfer to a position that could be performed in New York City. And this one applies to very small companies. Even if you just have 4 employees with 1 working in New York City, then you've got to comply with this one. Nevada has its own version of this law with varying triggers. Rhode Island has a version of these disclosure requirements with different triggers. Washington State has a version of this law with other triggers. And Washington State has a January 1 requirement to disclose in job postings wage scale or salary range and a description of all benefits and other compensation. That is going broader, of course, than the California law requirement. So there's not going to be any way that, like in this sort of a program, or really even probably a 2-hour program, we couldn't do justice to all these details, but we do want to at least make you aware of the flavor of what's out there and a sense of what you're going to need to do with your legal counsel to get ready to comply with these requirements. And I should mention, unfortunately, I've given you highlights here, but there's even more than what I've been able to put in the slides, and including even cities. There's cities in Ohio. Some trend has started there of cities passing these laws in other states. So there's a lot out there, and that's about the best I can do in our time today, is just to give you a general sense of it. Okay, so what are the recommendations? Definitely work with your counsel to identify for every work location you have, including remote work locations, give your counsel the cities and states where you have employees working to craft a form of job posting that will comply in all of those jurisdictions. Theoretically, you could have different postings for different jurisdictions, but that's going to be kind of a hot mess, I think, of complexity. And it could lead to morale issues of, why are we treating people differently? So I think for most companies, the best thing to do is just come up with a form with your counsel that's going to comply everywhere where you have a footprint of any employee headcount, even one remote worker working from home in that state or city. In addition to the job postings, we've got disclosure requirements to employees and applicants. So I would recommend prepare a policy on this of when you're going to disclose this information based on the disclosure triggers. There's different disclosure triggers in these state and city laws. So let's come up with something that's going to comply everywhere that you have employees, and that'll be your policy. And then a disclosure form that is going to comply everywhere as well. So if you have employees in these jurisdictions, for example, that are requiring a disclosure of also not just salary range, but bonus and commissions and other benefits, well, let's just put that in a form that's going to work everywhere for all of your employees. All right, and I definitely recommend conducting an internal and external pay equity analysis. And consider especially the internal analysis, consider working with your counsel on that so that it could be under attorney-client privilege, because what if your internal statistics reveal you've got a serious legal issue with under equal pay laws? Well, we would hate to have to produce that in response to subpoenas or court discovery requests in a lawsuit. So, but if you do the analysis under attorney-client privilege, not only are you getting the benefit of getting legal advice, which everyone obviously needs for something like this, but it's also making it not discoverable because the analysis is done under attorney-client privilege. And remember, when you're doing these analyses, that California has a very strict equal pay law standard. The law used to be that we could justify a disparity based upon any factor other than sex or race or what have you, but that got changed because it was perceived as not being strong enough, and now the standard is it's against the law to have unequal pay across sex or gender for substantially similar work when viewed as a composite of skill, effort, and responsibility performed under similar working conditions. So we can't just, let's say, easily deflect some disparity by just pointing to something that's not sex or not race. We've got to have a more persuasive argument. I recommend training management on these pay equity laws. There's still some managers out there probably that don't realize you cannot ask the candidate about their prior salary history. You can't ask what they're making, and you can't consider that to justify their compensation. So the law has changed on that in recent years, and that's just one example of something I think under these recent laws where it would be very easy for a hiring manager to step on a landmine and ask the wrong question, or make the wrong decision about what they're basing their decisions on. And review your record-keeping practices, because these new laws do have record-keeping requirements, and we want to make sure we're complying with those as well. All right. I'm going to shift a little bit away from pay transparency to other kinds of employment laws outside of California. Yes, we're focused on California. We're here in California. Most of our clients are based in California, but when we're updating their handbooks and their policies, we have to account for other places where they have employees. So I'm just rattling off here some highlights to give you a sense of the kinds of things that you'd want to tweak in your handbooks. The way we handle these is, when we're updating a client's handbook, not only for 2023, but also for their current employee work locations, we ask them for their employee headcount by city and state, including remote workers, and we basically note in what we call local appendices at the end of the handbook any adjustments that need to be made to our main policies based upon where these employees are working. So, for example, in Colorado, a change coming up is that their paid family and medical leave insurance premiums are now going to be due January 1, and employees may start taking this type of leave in Colorado under state law January 1 of 2024. Illinois has a recent change, or a change going into effect January 1, where they have had a law for bereavement leave for the death of a child. That's being expanded to include death of other family members. And Chicago has its own employment laws here and there. One of them is that this was effective July 1 of this year, that you had to have this very specific language in your sexual harassment policies. For example, including a statement that sexual harassment is illegal in Chicago. Now, you probably wouldn't have thought to put that in your policy unless you knew about this law, right? So this is going to require an adjustment. And they have annual training requirements to prevent sexual harassment that needs to be mentioned as well. New Mexico has a recently enacted sick leave law that has different standards from California. As you know, unfortunately, most sick leave laws in each state and city, they just tend to be different and they tend to vary, just like these pay transparency laws. So if you've got anyone working in New Mexico, you definitely need to have a local appendix there to address the differences with their sick leave. New York State paid family leave is expanded to cover care for a sibling. Sibling was added to the definition of family members. That's effective January 1, 2023. Needs to be reflected in an adjustment to your leave policies in a New York appendix. Oregon will have paid family leave contributions and posting requirements starting January 1, and employees can apply for these benefits starting September 3 of next year. Virginia has a new leave law for unlawful detainer, being on leave because you're in an unlawful detainer case, basically an eviction case. So that's a new leave law there we should reference. Washington State now also includes 7 days of bereavement leave as far as for postnatal death or a stillbirth in its paid family and medical leave. And there's a lot of other differences between California law and other states and cities, and it's a myth to say that, well, California is stricter than everywhere. That's not true. So, basically the bottom line recommendation is for everyone needs to have their employee handbooks updated for 2023, that's for sure, but not just for the new laws, but have your council make sure to update it based upon your current employee work locations. That's, every bit as important as updating for the new laws. All right. Let's cover a couple more topics here before I turn it over to Mary. California Senate Bill 657. I'm just going to say this is a curiously ambiguously worded law, which basically says for any posting you're required to physically put up in the workplace, you may also email that to people. And I read that and I thought, is this me? Or is this law just really curious sounding? So I looked at the legislative history, see what the legislators are saying, and they're saying they don't understand it either. And they're just they couldn't really agree on anything more specific, so they just passed this. Well, all right. So I think the gist of what they're saying is that with remote workers that never would see a posting in the workplace, that you should be sending them something. You should be sending them something by email, basically. Now, that dovetails with some federal guidance, which I've included as attachment C, which basically says that employers should, for remote employees, have something electronic that covers all the workplace postings you're required to do on site. And they give you some standards for what's going to need to happen for that to be effective. They say it could be on an intranet, website, shared drive, or file posting system. It must be displayed in some means that the company is using customarily for notices. So it shouldn't just be for these legal postings, but hopefully it's some kind of electronic place where you're making other announcements as well. You must inform employees of how to access this. Now, this would dovetail with the California law, where you can do that by emailing employees, showing them where to access this stuff. And they have to be able to readily see this information. So it can't be something where they have to ask for some permission to access it. It has to be automatic. So recommendation on this topic is, if you've never thought about how are you getting workplace postings to your remote workers, you need to think about that. And this provides you some guidance for how to do that. Work with your council to identify all the postings for the cities and states and federal that remote workers need to be able to access. Set up something, probably in most cases, the intranet's a great place for that, your company intranet, and then craft some kind of an email going to employees that's informing them of where their postings are. That's basically it. Okay, employee arbitration agreements, and I think this is my last topic. So we have a tennis match going back and forth in the courts about AB 51, which was a California law that said that we can only have optional employee arbitration agreements, not mandatory. But that law got stayed by the courts before it would have gone into effect January 1 of 2020. So then what happened? September 15 of 2021, last year, that stay got reversed. So that basically indicated that as of then, AB 51 was operative, so that we could only have these optional arbitration agreements. But August 22 of this year, the court withdrew the order reversing the stay. So it makes your head spin. But basically what that means is that the stay is back on. So AB 51 is stayed, which basically means it would indicate we can, at least at this moment, have mandatory employee arbitration agreements. So what's my recommendation? So my recommendation is consult with counsel about whether to, if you're using optional ones, to go back to mandatory for now, or you could just decide, we just want to play it ultra safe and just stay with optional for the time being. By the way, if your company has never even considered having an arbitration agreement, definitely discuss that with counsel. There are pros and cons, but in my experience, most employers think that the pros outweigh the cons. And stay tuned for further rulings in this case because it's not done quite yet. So with that, I'm going to pause and maybe just take one question here verbally from Brian, and then I'll type in questions to the others because we need to give Mary some good time to wrap this program up. Okay, Brian?
Sure. So I'll ask you one question that combines a couple of issues, which
Great.
is, how would you handle a pay range in the pay scale document for a remote employee who may or may not end up working in California, where their pay would depend on the geographic location in which they're ultimately hired?
Oh, that's a great question. So that's not addressed in any of these laws anywhere that I've seen, but I think what I would do is, I would want to err on the side of compliance by disclosing, as much as I could, I guess. So you might have a particularly broad range, or you could actually put in there a couple of alternative ranges that indicates in some way it's based upon the labor market. So you may have one for major metropolitan areas and one for other locations. So I would say definitely that's a great question to talk with your lawyer about directly, but those are my quick thoughts. So with that, and sorry we're moving kind of fast here, but I'm going to switch this over to Mary.
All right. Good afternoon, everybody. Let me just get my slides up here. Okay. Well, any legal update is not going to be complete these days without talking about the COVID-related laws for employers. So starting with the California COVID-19 supplemental paid sick leave. As a refresher, this is a law that applies to employers with 26 or more employees. And it basically gives employees up to 80 hours of COVID-related paid sick leave. Now, the SPSL provides two separate banks of leave, each of up to 40 hours. Now, the first bank of leave of up to 40 hours is available to employees who are unable to work or telework due to any one of the following reasons: where they're caring for themselves, where they're caring for a family member, or it's vaccine related. The second bank of COVID-19 supplemental paid sick leave of up to 40 hours is available only if the employee or their family member for whom they're providing care tests positive for COVID-19. All right, so what's the update here? Well, the law was originally set to expire in September 30th of this year. However, AB 152 extended the obligations under the supplemental paid sick leave to the end of this year, to December 31st. Now, it does not provide an additional or new leave bank for employees or otherwise create new obligations for employers. It basically just pushes the deadline for when this law is set to expire to the end of the year. One notable change, however, for employers is that AB 152 does expand the permissible employer-required diagnostic testing of employees. So here's what the current law provides. It says that if an employee requests to use supplemental paid sick leave because they test positive for COVID, then the employer may require testing on day 5 after the initial positive test. Under AB 152, in addition to requiring testing on day 5 after that initial positive test, if the day 5 test result is positive, the employer is allowed to require the employee to submit to a second diagnostic test within no less than 24 hours. In addition, AB 152 provides that if the employee does not submit to the additional test at the employer's request, the employer is not required to provide additional supplemental paid sick leave. As a reminder, however, these tests must be provided to the employees at no cost to the employee. Another important note is that the 2022 COVID-19 supplemental paid sick leave law is clear that the obligation to provide the supplemental paid sick leave is in addition to providing any regular paid sick leave. So this is a totally different bucket from regular sick leave that employees receive. Also, this is separate from the obligation to continue pay and benefits for workplace exposure as provided under the Cal-OSHA Emergency Temporary Standards, which I'll talk about later. Right. Okay. So next up is AB 2693. An employer has various notification obligations when it is on notice that there's a potential workplace exposure to COVID-19. Now, AB 2693 goes into effect January 1st of 2023 and will stay in effect through January 1st of 2024. It says that an employer must provide notice within 1 business day of potential exposure to COVID-19 at the work site. So to be clear, what does a work site mean? It means that it's a building, a store, a facility, or other location where the worker worked during the infectious period. It does not apply to buildings, floors, or other locations of the employer that the individual did not enter, or locations where the worker worked by themselves without exposure to any other employees. That would include, their personal residence or some alternative remote working location chosen by the worker when they're working remotely. All right, so what do you have to provide in the notice? There's a number of technical things. You have to provide the dates the employee was on the worksite premises within the infectious period, the location of the exposures, including the department, the floor, building, or other area. Importantly, however, the location should not be so specific as to allow individual workers to be identified. You also need to provide contact information for employees to receive information regarding any COVID-19 related benefits to which they might be entitled under applicable laws. That could be, please contact Human Resources for information regarding COVID-19 related benefits. You also need to provide contact information for employees to receive the cleaning and disinfection plan that the employer is implementing. AB 2693 gives employers 2 options for providing the required notice. One is a worksite posting, and basically this would need to be displayed in all the places where notices to employees concerning workplace rules or regulations are usually posted, and that includes on any online portals. So in other words, if you have a physical location and an online portal, it should be posted in both places. It must remain displayed for at least 15 calendar days, and the employer must keep a log of all the dates the required notice was posted at each of the work sites. Alternatively, instead of a worksite posting, the employer can opt to provide written notification directly to employees who were on the same worksite premises during the infectious period. And the manner of communicating that notification would be really any manner normally used to communicate employment-related information, so long as it can reasonably be anticipated to be received by the employee within 1 business day of sending. So that could be by personal delivery or by email, for instance. AB 2693 also removes the prior requirement for employers to notify the local public health agency in the event of an outbreak. So that's no longer required. As a reminder, an employer needs to maintain records of these written notifications in compliance with the law, and that's for a period of at least 3 years. All right. Another new law that was passed is Senate Bill 1044, and this provides for certain rights of workers in the event of emergency conditions. So what's an emergency condition? It's defined as a condition of disaster or extreme peril to the safety of persons or property at the workplace or worksite caused by natural forces or a criminal act. So it could be, for example, natural forces like an earthquake, right, or a criminal act. Or an emergency condition could mean an order to evacuate a workplace, a worksite, or a worker's home, or the school of a worker's child due to natural disaster or a criminal act. Importantly, the Senate bill provides that emergency condition does not include a health pandemic. Now, in the event that there is an emergency condition, an employer must abide by the following. So an employer cannot take or threaten to take any adverse action against an employee for refusing to report to or for leaving a workplace because the employee has a reasonable belief that the workplace is unsafe. An employer also is prohibited from preventing an employee from using a mobile device or other communication device to seek emergency assistance or to assess the safety of the situation or to communicate with a person to confirm their safety. There are a number of exceptions to these requirements for employees in specified jobs. Those jobs include positions in, public safety, employees who are emergency responders, certain healthcare and residential care employees, those in correctional facilities, military bases, nuclear power plants. So what I've done is I've included as an attachment the text of SB 1044 so that you can go through and take a look at the fairly long list of exceptions to this and see if any of your employees fall under any of these exceptions. And finally, just as a reminder, the law provides that these requirements do not apply once the emergency condition has ceased. All right, and finally, I want to talk about Cal OSHA's COVID-19 prevention rule. Currently, there is an emergency temporary standard, the ETS, that remains in effect through the end of this year. The last version that was updated was back in May, and we spoke about that at length during our August mid-year update. So I won't go into all of the particulars there. One thing I do want to just point out is that there is a change to the definition, what is a close contact? And the reason for that is because that definition was updated under the state public health officer order. So now it applies to the ETS. And basically, the definition of close contact is now dependent on the size of an employer's indoor space. For indoor spaces of 400,000 cubic feet or fewer, a close contact is someone who shares the same indoor space for a cumulative total of 15 minutes or more over a 24-hour period during the COVID-19 cases infectious period. For indoor spaces that are very large, that are greater than 400,000 cubic feet, a close contact is someone who's within 6 feet of that COVID-19 case for a cumulative period of 15 minutes or more over a 24-hour period during the infectious period. And again, spaces that are separated by floor to ceiling walls, such as offices, bathrooms, conference rooms that have floor to ceiling walls, those are considered separate indoor spaces. One thing I do want to just finally note about the Cal-OSHA COVID-19 prevention rules is that the Standards Board is working on proposed non-emergency COVID-19 rules. And if passed, they would likely be in effect January 1st of 2023 and stay in effect for a 2-year period. However, there remains really a great deal of disagreement about the provisions currently contained in the proposed non-emergency regulations. The board is scheduled to meet again in December, and it's possible that they may conduct a vote at that meeting or prior to then to approve some final version of the proposed non-emergency COVID-19 regulations. So what this means for California employers is you should continue to comply with your obligations under the current emergency temporary standards through December 31st, but stay tuned for a non-emergency version of these rules that might go into effect January 1st. The good news is that it looks like many of the elements will probably stay the same as under the ETS. If anything, those guidelines will likely be relaxed or some of them might be eliminated. But one thing that probably will stay is the requirement to have a written plan to address COVID-19 in the workplace. All right, well, that concludes our program. Ray, Brian, and I will stay on for a few more moments to try to answer some of your typed in questions in GoToWebinar. I do want to just let folks know that we will do a more in-depth program in January, our annual legal update that will be 2 hours, where we'll cover these subjects in more depth and some additional topics. Also, we expect to be doing a harassment training for sort of end-of-year compliance to help employers send their managers and their employees to. So stay tuned for that invitation. All right. Thank you so much for attending our program.
Thanks, Mary. I will go ahead and ask you a couple of questions for folks who can stay on. And also for folks who can stay on, I'll just note that we will stay logged in even maybe 10 or 15 minutes after we stop talking and keep typing in questions to folks who have questions if they're still logged on. So just to let you know that. But with that, Mary, I'll go ahead and bounce a couple questions off you for folks who are interested to stay to hear these. So one question is, we have the supplemental sick leave in California for COVID, that's 26 or more employees, and then we've got you mentioned the emergency temporary standards that has this paid leave for folks exposed to COVID in the workplace. And the question is for the ETS, the exposure type of paid leave, does that apply to any company with one or more employees, or is there a different standard?
That's a great question. So the emergency temporary standards that Cal-OSHA has published applies to employers with one or more employees. So if you have one or more employees in California, you should make sure that you're in compliance with the ETS. And under the ETS, if you have an employee who has a workplace exposure to COVID, then the ETS requires that you continue their pay and benefits during the time that they need to be excluded from the workplace.
Great. And then I'll just ask really kind of a combo last question regarding these safety-related laws. You've covered AB 2693 and Senate Bill 1044. Basically, just the question was, what is the employer size to be covered by those two laws?
Sure. Those two laws don't specify any minimum size. So if you have one or more employees, you would be covered under those.
Right. Safety laws, generally speaking, I would say the law wants everybody to be safe, and so that's not a big surprise. So, okay. Thanks everybody for attending, and we'll look forward to seeing you on the future program.